In this case, Stephanie suffered some sort of mental harm akin to that of a panic attack and spent 2 days in the hospital. This was as a result of Michael telling her that her boyfriend of 3 years, Ahmed, was in a serious car accident. Despite Michael claiming that it was a joke, Stephanie would now like to know if she has a claim in the tort of intentional infliction of harm. The facts of her case are very similar to that of Wilkinson, and if the rule in this is followed, then she would have a strong claim. In Wilkinson, a woman was incorrectly told that her husband had broken both of his legs on a trip, resulting in her suffering from severe nervous shock, just similar to Stephanie. In this case, Lord Wright said, the defendant has willfully done an act calculated to cause physical harm to the plaintiff, that is to say, to infringe her legal right to personal safety, and has in fact thereby caused physical harm to her. If this ruling is followed, Stephanie would have a claim, as there was harm caused to her, and there was intention to cause this harm. In both of these cases, the intention can be inferred from the claim that it was only a practical joke. However, it is argued that there is now little, if any, room in the law for the rule in Wilkinson to operate, weakening Stephanie's case. This is a result of both statute and case law. For example, in the one case, the Court of Appeal rejected the idea that you can recover damages for distress, despite there being actual or imputed intention, and instead you need actual physical or psychiatric injury. As Lady Hale said, for the tort to be committed, there has to be actual damage. The damage is physical harm or a recognised psychiatric illness. The defendant must intend to violate the claimant's interest in his freedom from such harm. Stephanie only suffered emotional distress, which unfortunately isn't enough to claim under this tort. Further weakening Stephanie's claim is the case of Rhodes, where the Supreme Court laid down 3 requirements of Wilkinson. First is the conduct element, which is unjustified words or actions directed towards the claimant for which there is no reasonable excuse. Secondly is the mental element. This is where subjective intent may be imputed as a matter of fact if the defendant intends to cause severe distress and causes psychiatric injury. This imputed intention can be to cause any sort of stress. It doesn't just have to be an intention to cause a recognised psychiatric injury. These first 2 elements are both present in Stephanie's case, but it fails upon the third element, which is the consequential element. This is the physical injury or recognised psychiatric illness which Stephanie does not have. This leads me to believe that she does not have a claim under the current law and cannot receive damages. This seems very unfair upon Stephanie, as it's almost as if she's being punished for not suffering a recognised psychiatric injury. I would agree it is also dangerous, as Michael's imputed intention did have the potential to cause serious mental injury, so it's unjust he does not have to pay damages just because the actual outcome was less serious, because his intention was still the same. This leads me to argue that there should be a new tort of intentional infliction of emotional distress to protect innocent victims such as Stephanie. Lady Hale said, since the passing of the Protection from Harassment Act, there is no need for the rule in Wilkinson, as anything less than psychiatric harm is covered in the new Act. However, as shown in Levi and Bates, this requires a course of conduct, where 2 acts need to be committed for it to amount to a harassment. This still does not cover a victim such as Stephanie, as it was an individual act. The blind spot of the Act is also highlighted in the case of Veekins v. Keir. The actions of the defendant again does not amount to harassment, as there wasn't multiple incidents. But Maurice K. LJ recognises that there was conduct that was oppressive and unreasonable, yet this carries with it no punishment. Surely this highlights the need for a new tort. The gap between the statutory law of harassment and the tort of intentional infliction of harm is large enough that something is needed to fill it. Without it, there is a weak spot in protecting the very aims and functions of tort law, in this case, vindication, which is that the claimant's right to be protected from distress is upheld. Without a new tort, this isn't the case. Furthermore, it is also as if the claimant is being punished for not suffering some sort of psychiatric harm like depression. It doesn't seem right that just because the claimant is lucky enough to only suffer a minor trauma, they don't receive any damages. Particularly in this case, the fact that the defendant, Michael, was an ex of Stephanie's offers a strong claim that there was malice in his actions, potentially fueled by jealousy, and that Michael may have had more than only imputed intention to cause serious psychiatric harm to her. If Michael is not subject to damages, then there is no deterrent for him to do another act similar. The Harassment Act again fails in this respect, as Stephanie is also being punished for only having to go through the trauma once. It's almost as if it would have worked better in her favour if there were multiple incidents. If there was a new tort, I'm aware that there would be a number of criticisms if it was to be created. It has been said that it could create a floodgate of claims, and most of which will be, as Lord Hoffman put it, one-off boorish incidents. However, I disagree. Up to now, the rule in Wilkinson has only been used in 2 cases, that of Wainwright and that of Janvier. Only 2 cases, despite the fact that this was over a century ago, emphasising that the idea of the floodgate may just be an overreaction. This is most likely because it could only ever be applied to a very limited set of facts in the first place, so it's improbable that if there was a new tort it would be overused. It is not really a common occurrence for few words to amount to such mental trauma, and for this rule to be used it has to be exactly those circumstances. Furthermore, in my opinion, it may be unfair to say that some incidents are boorish. A claimant's right to be protected from distress should be upheld, just as much as their right to be protected from physical harm, despite how petty and repetitive some claims may seem. This is one of the main aims of tort law, so it shouldn't be overlooked. Also, others may argue that the idea of a new tort of an intentional infliction of emotional distress is not what Parliament intended when they created the Act. It could be said they put harassment into statutory law, as this is exactly what they intended to do, and it covered exactly what they intended it to cover. Hence, even the suggestion of a new tort may be seen to be going against parliamentary sovereignty. It has been said by the High Court of Judiciary that an Act of Parliament, duly passed by the Lords and Commons and assented by the King, is supreme, and we are bound to give effect to its terms. And it may be wrong to suggest that there had been an element left out. However, the extent to which Parliament should be sovereign has long been debated, with those such as Wade stating that there is no statute which says that the courts must enforce without question of Acts of Parliament. It is hard not to question a possible element being omitted when there is such an obvious injustice to victims such as Stephanie. Through no wrongdoing of her own, the victim was placed in the situation, so deserves justice for it. In conclusion, a new tort of intentional infliction of emotional distress should be made, but I do agree that there should be limitations. In Wainwright, Lord Hoffman warned that if you adopt such a principle, you have to be very careful about what you mean by intend, and I think that that's the main issue. I would agree with the caution or the idea of the floodgate may become a reality. This is why I think that if the new tort was to be created, there should only be actual intention and not imputed intention. Also, this way, it will not interfere with what Lord Newburgh called the give and takes of ordinary human discourse. A simple exchange or not a very courteous words should not amount to a claim in tort. There should have to be a direct intention to cause the emotional distress. That is emotional distress of any sort, not just those that are recognised psychiatric injuries. Finally, if the new tort is found to be created, I think the defendant should have to pay just damages. As this tort is on a much, much lower level than other torts, anything more than this would be excessive and may reduce the credibility of the justice system.